It's my honor. I'm Terry Davidson. I'm the Public Affairs Counselor at the U.S. Embassy. It's so wonderful to have Justice Ginsburg and Justice Dorit Beinish here, the first woman to serve as President of the Israeli Supreme Court. You all know who these women are. You know how to use Google, so I'm not going to read bios because it's a waste of time. We don't have that much time. I want them to have the floor. But before we started, I just wanted to say on behalf of Ambassador David Friedman, my colleagues at the U.S. Embassy, a number of whom are here today, it's a great honor for us to join the Genesis Prize Foundation in welcoming Justice Ginsburg to Israel and for honoring her with this Lifetime Achievement Award. A trailblazer since her early days at Harvard, she's been a voice for equal treatment under the law, a voice that has been heard. I'm the husband of a very strong woman, and I am the father of an even stronger young woman, and for that I thank you very much for all that you've done for them. So as I promised, I'm going to get out of the way, and I'm going to turn it over to Justice Beinish, who is going to have a conversation, and then sometime in the conversation, we'll open it up to some questions to all of you. Justice Ginsburg, you can have the floor again.
Okay. I suggested to Dorit that we might start by speaking of the differences in the Supreme Court of Israel and the Supreme Court of the United States. These are two courts that are known throughout the world for judicial independence. And it's something we hope we can keep. It requires a public that understands the tremendous value of having courts that are free from any influence of the government. So,
yes, for transparency, it's not the first time that we meet, and I think we share the same values, and it's a bit boring, the downside, because there is no controversy, but we come from a different background, of course, and I'm glad really to welcome here Justice Beda Ginsburg in your 5th visit in Jerusalem, you said?
yes.
And this is really a great honor, and you know that I want to shorten, I don't have to introduce Justice Ginsburg, all of you here, this audience knows you, knows your opinions, and knows your contribution to rights, to women's rights, to minority rights, and we all really admire what you did. So I think we'll start. I agree that the most important issue now is the independence of courts. It's part of the system. Unfortunately, we see countries, democratic countries, that were democratic countries, and their courts are losing their independence. And I think this is the most important thing for a court, as you said, to be independent. So we are coming from different systems, but the same values. I would like Justice Ginsburg to start and tell us, you came to hear Justice Ginsburg, you know my views, but this is the opportunity to hear about your system and what you have to tell us about it. Please, Justice.
How are we selected? Well, we're nominated by the President and confirmed by the Senate, and the Constitution preserves our independence in 2 ways. One, we hold our offices during good behavior. That means essentially for life. I think we are the envy of judges all over the world. Israel has much too young retirement age by my standards, 70. I would have been gone 15 years ago. So the Constitution says we hold our offices during good behavior, and our compensation can't be reduced while we're in office. That was the founders thought that would be a way to prevent the Congress from retaliating if they didn't like what the court was doing. Now, people sometimes say to me, well, it's political because you're nominated by the President and confirmed by the Senate. Well, throughout history, presidents have been disappointed by their nominees. To take 2 famous cases, President Eisenhower nominated Earl Warren, who was a tough prosecutor. He was governor of California. He signed on to one of the worst mistakes the United States ever made, which was the internment of the Japanese Americans in World War II. So he was expected to be tough on crime. Turned out that he led the court to end apartheid in America. And the other Eisenhower nominee, William Brennan, was also a leader of the, quote, liberal wing of the court. So there is, I think, some value in being before the Congress and answering questions. We're going to spend the rest of our lives asking questions. So on the whole, I think the process works rather well. One large difference between Israel's court and ours is that our docket, our cases, it's almost totally discretionary. So we decide what we're going to decide. And if we think a case may be terribly important to the litigants, but it's not of national importance, we don't take it. We get upwards of 7,000 petitions a year, and from those we select somewhere between 70 and 80 to set down for full briefing and argument. So, Dorit, maybe you would, Dorit, you would explain the differences in that regard. I know that the caseload of the Israeli Supreme Court is anything but discretionary.
Of course, because we are a court of appeal, not only a court of judicial review. On judicial review cases, we do have discretion. But the background is, of course, different because unfortunately, we don't have a constitution. We do have basic laws that give us the authority, this is what we think, not the politicians do not agree, but to review legislation too. This is a constitutional court. On those issues, we are working with discretion. But of course, appeals are by right, and the court is overloaded with cases that maybe shouldn't be in that court. The thing is that we don't have the guarantees that you have, according to your constitution, for being, the balance. And our politicians envy your system because they believe that a political system of nominating justices is the best for them. Mm. I don't think it's a good guarantee for separation, and we were very proud to have an apolitical system of nominating. But this is part of the whole system, as I said, not having a constitution. And in our situation, I would like to be in a Senate commission asking questions what I think about everything. I think none of the justices would come to the court after this. But really, to be serious, we have an independent court, and this is very important, as you said, and we have discretion in judicial review cases. We do have. But the special system where people have direct access to the Supreme Court on judicial review brings much more cases to the court than, of course, in your case. You said you have thousands of petitions, but you can decide, and you decide on very few if you compare with our numbers. But the composition, of course, of the court is different. We have 15 justices, we sit in panels. The system is very different. As I say, we share the same values, we have the same background in a way, but history brought us to be without a constitution and different than, of course, your system. I hope we keep this independence of the court, which is the most important thing. I agree.
But you do have the two basic laws that have
Yes,
something
yes.
like constitutional stature.
Yes, very important. This is our judicial review on legislation, of course. We do have. Again, it's not in the Constitution. It's very similar. We took like a member of medicine. The court said that this is the role of the court to interpret the basic laws. And this is our authority. Again, politicians are not very happy about it. It's always, I think, all over. But this is what the court does. And this is the most important jurisdiction that we have.
One difference in the mode of operating, you have 15 justices, and you sit in panels.
Yes.
Ordinarily 3, it can be larger
Yes.
for more important
Yes.
cases.
Yes.
We at the Supreme Court of the United States is a lot of togetherness. All 9 of us do everything.
Yes.
We never divide into panels.
Yes.
So we're deciding what cases we're going to decide. All of us do that. All 9 of us hear all the cases set down for argument. All 9 of us participate in the 11th hour petitions to stay in execution. So that's a big difference from working
Yes.
with panels or working with all
A
9
big
of us.
difference. A big difference. And I don't know. There is a tendency to label justices in the American court more conservative and liberals. I believe, as you said, after swearing in, judges' commitment is first of all to being a judge and not to the political party that nominated or to someone. As you said, very famous cases in the United States. It's not always like the Warren case, but this is because judges are first of all committed to their role as a judge. So, and we sit in panels of 3, but on constitutional matters we enlarge the panel to 5, 7, even 9. It depends how important the case is. So we do have larger panels too, especially, of course, on constitutional matters. And we don't have enough tradition of interpretation of the basic laws, but it was developed very nice, very good as a judicial review by President Barak and the court later. The thing is that I wonder if the guarantee for independence is that you cannot remove a judge from office. Is it enough to guarantee the independence of a court? I often think about it now when things are happening everywhere.
I think all of us, whether we were appointed by a Republican or a Democratic president, I mean, the one thing that we care most about is preserving the institution, preserving the independence
Yes.
of the judiciary from the president and the legislature. So, for example, my friend Justice Scalia, although we disagreed on a lot of important questions of statutory and constitutional interpretation, but he was a fierce defender of the independence of the courts.
Of course. Well, this is, I think, the main principle for justices, to keep this independence. Can I ask you, Justice Ginsburg, the last term, there were many of your court. There were many important decisions, and I can say with admiration that you remained in your dissent opinion, not alone. You had very important dissents. And it's important to understand, do you believe as a justice, what is the role of a dissent? I mean, I think it has an important role, but I wanted to hear it from you.
There are 2 kinds of dissents. One is if it's a question of statutory interpretation. in those cases, if you're dissenting, your audience is the Congress, because Congress can change it. So just to take one of many examples, in the 70s, a case came to the court presenting the question, is discrimination on the basis of pregnancy discrimination on the basis of sex in violation of Title VII, our principal anti-discrimination in employment law? The court said, no, because the world is divided into people, and that includes men and women, and then pregnant people. So the class of people included men and women. There was a coalition, people from all parts of the political spectrum, united in pressing for legislation that was the soul of simplicity. The Pregnancy Discrimination Act said discrimination on the basis of pregnancy is discrimination on the basis of sex. Wrong decision by our court on a question of statutory interpretation, the legislature can change it. If it's a question of constitutional interpretation, the legislature can't change it because the court has the last word on what the Constitution means. So a dissenter in a constitutional case is looking toward a future court that will see the error that a predecessor court made. And we have had a long history of important dissents, starting with the most dreadful case the Supreme Court ever decided, the Dred Scott case. There were 2 dissenters there. And then at the end of the 19th century, when the Supreme Court entrenched the separate but equal doctrine, there was a powerful dissent by the first Justice, John Marshall Harlan. At the time of World War I, when there was a fear of left-wing socialism, communism, 2 justices wrote in dissent, Brandeis and Holmes, on the right of freedom of speech. Those dissents are today the law of the land. So a dissenter is writing for a future court and hoping that that court will correct the error of its predecessor.
So it's looking to the future. It's very, I think it's very influential and important to find the minute that the dissent becomes the law of the country. And it happens, but it
Yes.
takes time.
Yes.
It is true. And this brings me to a question about can court decision, and I must say first, the background for my question is your tremendous contribution and the influence on rights of minorities and especially rights of women and gender equality. And this is, and we see the results. I mean, the world where you started at the ACLU and later in the court changed, really changed, and most of it is thanks to your fight and your opinions. And the question is, how much can court decisions influence social phenomena and the society? And that field, I think, it's not finished, but there is a great influence of your contribution. But is it really a tool for changes, or is it not enough? Or can we do it as courts to change our society on certain, of course, basic rights and values?
Social change never begins with courts. There has to be a groundswell. There have to be people who care deeply about an issue and want to make things a little better. So for example, into the 60s, the Supreme Court never saw a gender classification it didn't like, or at least didn't think was constitutional. My favorite example from the liberal Warren Court is jury duty for women. The case was a woman, Gwendolyn Hoyt, whose husband was an abuser, a philanderer, and one day he humiliated her to the breaking point. She spied her son's baseball bat and lifted it, and with all her might hit him over the head. He fell against a stone floor. That was the end of their argument and the beginning of the murder prosecution. But Hillsborough County in Florida didn't put women on the jury rolls. Gwendolyn Hoyt's thought was not necessarily that women would vote to acquit her, but they might convict her of the lesser crime of manslaughter instead of murder. So she was convicted by an all-male jury of murder. And when her case came to the Supreme Court, the attitude was, we don't understand this complaint. Now, women who want to serve on juries, it's true that they're not on the rolls to begin with, but they can go down to the clerk's office and volunteer, and we'll put them on the rolls. Well, how many people, if they had the opportunity to escape jury duty, would go volunteer? Not many. That was in 61. In 70, with a Chief Justice Berger, who was considered, quote, conservative, the court struck down one after another gender differential in the law. It was catching up to the changes in the way people were living. Now, one example of the change in time. My daughter was born in 1955. I was then one of very few working moms. My son, who was born 10 years later, he was 65. It was not at all unusual to have two earners in a family. So it was that change that was occurring in society, and the courts were catching up with it and moving in the direction of the change, reinforcing the change that was occurring in society.
I really believe that changes there is a mutual influence. I mean, changes in society, the court should be attentive and to know that society changed and to understand society. And the question is how much we can influence with our norms. Here too, in the 60s, we had legislation, and still exists, that was meant to protect women. As you said, I heard on a pedestal, but this was the cage. In a different age of retirement, not enough jobs for women, a military service, your famous VMI case. Here too, this was the problem. Women were not admitted, although I think the situation was better than in the States in working places. Women were more active. But it remained not as an advantage for women now, but a disadvantage for women. So it's similar to the jury case. I would ask not jurors that understand the woman, but the women justices. I often thought that the silly question is there a difference if it's a woman a judge or a man? Now I think it's not so silly. I started to believe that there is a difference, and I want to hear your opinion. I noticed that all the dissents in the last cases, the women were the same opinion. It happens here too. Is it by chance? I don't know. I don't know the answer. I really don't know. What do you think about it?
Well, now, it's true that on this court, the three women vote alike in most cases. So I think my agreement with Justice Sotomayor must be about 95% of the cases, and maybe 93% with Justice Kagan. But we all bring to the table our life experience. And to give you one illustration, a girl in the 8th grade was suspected of having contraband. It turned out she had 2 Advil pills in her purse. But because of the suspicion, she was hauled off to the girls' bathroom and she was strip searched. And then she was put in a chair outside the principal's office to wait for her mother to pick her up. The mother was furious about the humiliation that her daughter was exposed to. And so she sued under our civil rights legislation. She sued the school district. Mm-hmm. And at the argument began to be rather lighthearted. One of my colleagues mentioned that the boys, when they go to gym, they undress and it's no big deal. And I said in court, there is a difference between a 13-year-old girl and a 13-year-old boy in her sensitivity to her body. And then the lightheartedness stopped. People thought of their daughters, and they recognized that this was not an occasion for light banter.
Yes, I see that people, you want to distribute the mic for questions from the
Yes, what
audience?
we'd like is, hands up already, is to offer the possibility for questions. So, but please, no questions about current cases that are before either courts, either of the Supreme Courts. Thank you very much. And if you could explain who you are, just mention who you are.
Judge Ginsburg, I'm Rabbi Nama Kelman, and I pray for your health and long life daily. It's an honor to be here, and my question is about Justice Kennedy's retirement and how do you foresee maintaining the balance on court and maintaining some of the most important laws that have been put into effect in the coming decades.
We don't know who the nominee is. The president said he will announce his nomination on July 9th. How much time it will take to investigate him? Now it takes just a majority of the Senate, which the Republicans have at the moment, may not have after the midterm elections. So we don't know if the president will be successful in rushing his nominee through before the midterm. If it gets to the midterm and the balance in the Senate shifts, it'll be a different story.
If the process starts on the 9th, it could go on until the midterm?
Well, it takes, first there are endless forms for the nominee to fill out.
Yes.
Disclosure, financial disclosure.
Yes.
And then the committee has hearings. So my nomination was one of the most rapid. I was nominated on June 14th and confirmed on August 3rd.
By such a vast majority, almost 97
Yes.
to 3. Yes.
My name is Anat Hoffman. I'm one of the women of the wall. And I wanted to ask you about the principle of separate but equal. The issue of women of the wall is that women want to wear a talit, pray out loud, read Torah, put on phylacteries at the women's section of the Western Wall. This causes a lot of issues with the Orthodox powers that be. And the solution, in principle, is to remove us to a different place at the wall, another plaza, a separate plaza. And I'm wondering, what do you think about the principle of separate but equal in a religious holy place?
And that isn't it a pending case today too?
I'm talking about the principle, not the...
Principle we know. The principle we
principle
know.
of
And they are
separate
forever
but
in the
equal.
court because I think it's 7 or 8 times already, yes? Anyway, I was there when it started and not even when it
So can we
started.
address just the idea of separation, of separate but equal in a holy place? Is that a solution in your mind?
Well, I can't speak to Israeli society in that regard. I would certainly say that in the United States, the notion of separate but equal has such a odious past. But in Israel, Israel does have an established church. It is the Jewish religion, and Dorit can speak to this better than I can, but much of the authority over religious matters has been given over to the religious communities. I mean, what do I think about the idea that a woman can't get a divorce, she can only receive a divorce? That would be certainly a violation of the equal protection principle in the United States, but Israel is different because it does have a state church. I don't understand it very well, but to the extent that I do, the religion is Orthodox.
Mhm.
Now, that I think in the United States, there are many more conservative and Reform Jews than there are Orthodox. And I'm proud that in both the Reform synagogues and conservative, women are rabbis. I remember in the 1970s meeting with the head of the Jewish Theological Seminary. The Reforms had already admitted women to the rabbinate. And so the head of the seminary asked me, well, we admit women to the cantorial program. Isn't that enough? And my answer was, it's not enough if you want to keep the young people involved with the synagogue. Because the young people growing up now don't understand that people should be excluded simply because they're female or male. But I think the one of the reasons that that women have been accepted as rabbis in the United States is that concern for the next generation. How will they feel about their religion? I remember how jealous I was of my cousin who was 3 months, it was 3 months different when he was bar mitzvah, and there was no bat mitzvah.
Mhm.
In fact, Justice Kagan was the first girl bat mitzvah at her west side of New York shul. It wasn't on a Saturday, it was on a Friday, and she didn't read from the Torah. She read from the book of Ruth, but it was a beginning.
I think it's our problem is we don't have a separation of state and religion, and unfortunately, religion is part of politics, and this is really a serious problem. But I must say the tension on religious matters exists probably not the same, of course. If I understand your court's decisions like Holy Hobby or others, the religion is there, they use it. Not as much as, of course, here, because here, as you said, the Orthodox are, we try, they are dominant, and they're in the government, they're part of our politics. It's a very serious problem. Those are problems that the court cannot easily, if I say in an understatement, solve. Those are really serious problems, and as you said, the law for women, no equality in rabbinical courts where there are matters of marriage and divorce. And equality is not in our basic law. One of the reasons is because of the religious parties who didn't want to accept it. But we do have equality in our more than a basic law for women's rights, which was one of the first legislation in the 50s in Israel.
We have a question from Professor Shikri.
Good morning. I appreciate very much both comments and excellent dialogue. My name is Shimon Shitrit. I'm from the Hebrew University, and I want to ask, from your very, very long legal career in the top court, what is the secret of the stability of the system of government and the relations between the branches in the United States? Is it because there is a better and careful respect between the branches? For example, the enrolled bill rule, which the Supreme Court has continued to be committed to, not interfering in internal congressional procedure once a bill is passed and signed, when in our case it's not. Our Supreme Court thinks it's okay for the court to intervene and to interpret the internal procedure of accepting law. So what are the secrets that you think have contributed to the stability for so many years in the United States, particularly in the relationship between the branches and the Supreme Court, the political branches and the Supreme Court?
As you know, we have a separation of powers, but also the Constitution gives each branch a foot. In the other's camp, in the interest of not letting that branch become too powerful. I think if you took a poll of the institutions of government in the United States, what do the people think? The judiciary would come out far ahead of the legislature and the executive. Perhaps it's that we've been at the business of judicial review for constitutionality for so long, since the beginning of the 19th century. And we do try to maintain rapport. One of the, every time there's a new Congress, there's a dinner at the Supreme Court for all the senators. The women in Congress and the women in the court meet once a year. It started out, I think it was just Justice O'Connor and me and 6 senators. So we rotate. One year the dinner is for the court to host, the next year for the members of Congress.
I I dare say that in the polls, still, in spite of being criticized, our court is also the first if you compare with other branches of government. So this is a bit encouraging. Sometimes we are understood by the people. I think so. This is the situation if you see the polls here. Unfortunately, it's important that the other branches, of course, will also have, but this is the situation.
Thank you both to President Beinish and to Justice Bader Ginsburg, not only for being here at this event, but also for all your incredible work. Justice Bader Ginsburg, your approach, your jurisprudential approach, and your approach as a litigator was always slow and steady, incremental change. Do you still believe in that approach when it seems that rights protection is actually regressing?
The court generally moves incrementally. It doesn't take giant steps. Even in perhaps the most noted case of the 20th century, Thurgood Marshall, who was a brilliant litigator, many times said, separate but equal is not before the court today. These facilities are not equal. And then when he had his building blocks, then he was finally able to say to the court, separate can never be equal. But he started with the University of Texas when it realized it couldn't exclude African Americans from legal education, set up a separate law school for them, vastly inferior to the University of Texas. And then there were several other cases. In our gender discrimination litigation, I kind of thought of myself as a kindergarten teacher because my audience didn't think such a thing existed. I mean, they thought of themselves as good husbands, good fathers, and to show them that the pedestal too often turns out to be a cage. That was the challenge for them. So my idea was to try to get them to think of what they would like the world to be for their daughters and granddaughters.
My name is Grace Rudnitsky. I'm with the Ethiopian National Project that works to ensure the full and successful integration of Ethiopian Jews into Israeli society. But actually, I'm asking as a mother of three, two of whom are teenage girls. And I wanted to ask you what your message to teenage girls is today.
One, that they are fortunate to live at a time when there are no closed doors. And to whatever calling they pursue, they should, if there's something they're passionate about, they should pursue that. Never alone, but whether it's the environment, whether it's human rights, to join together with other like-minded people. So I think it's a good age for daughters. When I think of it, my granddaughter just graduated from law school. When I attended law school, women were less than 3% of the lawyers in the United States. There were 9 women in my entering class and over 500 men. My daughter went to that same law school. The women were then 25%. When my granddaughter, who just graduated, attended that school, it's now 50-50. They had 2 women deans in a row, including Justice Kagan, my colleague. And in all my undergraduate years and law school, I never had a woman teacher. When people ask me, did you always want to be a judge? It would be most impractical goal because the women weren't there. I mean, the first woman ever appointed to a federal appellate court was Florence Allen in 1934, appointed by Franklin Delano Roosevelt. She retired the year I graduated from law school, and then there were none until 1968 when Johnson appointed Shirley Hufstetler. Shirley Hufstetler became the first ever Secretary of Education, and then there were none again. The credit for the change in the face of the judiciary is due to President Jimmy Carter. As he looked around at the federal courts and he said, they all look like me. But that's now not how the people of the United States look. So he made it his mission to appoint women and members of minority groups in numbers to the court, not as one-at-a-time curiosities. He never had a vacancy to fill on the Supreme Court, but he literally changed the complexion of the federal judiciary, and Reagan, not to be outdone, was determined to put the first woman on the Supreme Court and made a nationwide search and came up with a wonderful choice in Sandra Day O'Connor. And the first woman appointed to a federal district court, a trial court, Bernita Shelton Matthews, was still alive when I was appointed to the Court of Appeals. She was in her 90s, and I had the benefit of many conversations with her. When she spoke about the days when she was a member, in fact, she was counsel to the National Women's Party. That was the group that wouldn't settle for the vote. They wanted the Equal Rights Amendment. She, during the suffrage campaign, she told me she would go to the White House, hold up her sign, Votes for Women. If she was hassled by the police, she would never respond because she didn't want to risk having an arrest record, which might make it difficult for her to become a member of the bar. When she was put on the bench by President Truman, none of her colleagues hired women as law clerks. So she hired only women as law clerks. And she thought she had the best of that bargain.
Justice Ginsburg, thank you so much for coming. My name is Andrew Abordinato. I'm an economic officer at the U.S. Embassy here in Israel. Also, I have to extend a personal thank you to you as a gay man that hopes to be married one day. I'm eternally grateful for you affirming my constitutional right to wed. So I'm hoping you'll help me understand something given the political situation moving forward with the courts. When the Supreme Court, my understanding, affirms certain constitutional rights, it seems or it's perceived by the general public as something that is now written in stone, pending a change in the Constitution. So to what extent is it possible with the makeup of a new Supreme Court for certain constitutionally affirmed rights to be rolled back, and how swiftly can that be done? Thank you.
Precedent is very important on the court. The Latin word is stare decisis. Once the court decides, it doesn't lightly change the decision. And of course, stare decisis is not an absolute command. But let me give you one example. You probably know about the so-called Miranda warnings, a decision during the Warren Court that the police must tell someone who's arrested, you have a right to remain silent. If you speak, what you say can be held against you. You have a right to counsel, and if you can't afford one, the state will provide counsel for you. Justice Rehnquist, when he was a justice before he became chief, was severely critical of the Miranda decision. He dissented a number of times in cases where Miranda was controlling. But then when he was chief, we got a case that was a frontal attack on Miranda. The court was asked to overrule Miranda. The chief wrote the decision upholding Miranda. He said, this has now become part of the culture. And so he felt the weight of precedent.
We have time just for 2 more questions, so unfortunately not everybody's going to be able to ask, but
Justice Ginsburg, thank you for coming. This is a great, great honor. My question is with the court, the chief, the highest court, mirroring the polarization in politics in America and being more and more out of step as far as the balance between conservatives and liberals compared to the popular vote. What do you think about the suggestion of making an amendment which will allow for only an 18-year tenure for each justice, and that will make it available for each president to nominate two justices in a regular way?
It's an academic question. Could there be term limits for Supreme Court justices? In order for there to be term limits, the Constitution would have to be amended. And the U.S. Constitution is powerfully hard to amend. You can see it with the Equal Rights Amendment. And I'm a resident of the District of Columbia. The district wanted something equivalent to statehood, have a representative. So we have taxation without representation in the district, but that amendment also failed.
Hi, thank you both for your inspiring comments. My name is Rachel Yael. I'm the chair of the Association of Civil Rights in Israel and the board member of the New Israel Fund. As human rights organization in Israel, we are deeply concerned with the constant delegitimization and demonization against the Supreme Court in Israel. It worries us a lot because human rights in Israel see the Supreme Court as their last resort. And given the political climate, we are even more concerned. Can I ask you, from your very, very vast experience in the United States, what can human rights organizations do in this situation in order to at least help maintain the position of the Supreme Court as really an authority, unlimited freedom of the Supreme Court?
Having been affiliated with a civil rights organization, the ACLU, for many years, I was one of their general counsel and served on the board. We had 3 audiences. The first was for people to understand what rights they have and to care about defending them. So that was public relations. And the next is legislation. If we can't get legislation on the federal level, maybe there are some states that are willing to adopt it. But that's another difference between Israel and the United States. You don't have the opportunity to try something out in the States. And then finally, the court. And the Israelis should appreciate that the court here has been a model for other courts struggling to achieve independence. And it would be really a sorry thing if the court's wings are clipped and by the legislature. And we see how things can go awry. The Chief Justice of Poland goes to her court and she's
It's
locked out.
unbelievable, unbelievable.
Well, Justice Ginsburg, we thank you so much for carving out time during your
Yes.
visit to Israel for the American Center and our audience. And I think I join everyone here in expressing our deepest appreciation to you and to Justice Beinish for the time.